Today. Good afternoon. We're here to discuss the Secure Act 2.0 in a very conversational format, providing with general understanding of what our legislators meant to do in passing the act and what the practical outcome has and will be for you as small business owners and your employees. I'm your host, Carmela Elko, Managing Director at Trinity Advisors Group. And I'm joined here by my esteemed panelists, Michael McCabe, President at Trinity Advisors Group, and David Hall, Chief Marketing Officer at Hall Benefits Law Group. Welcome, gentlemen.
Thank you.
Yep. So just to give you some perspective, there are 92 provisions in the Secure Act 2.0. So if you found it challenging to keep track of what applies to your plan and when, you are definitely not alone. We're here to give you a general understanding of some of the most impactful provisions that apply to small businesses, focusing on when they become effective and what you should be thinking about from a planning perspective. We're also conducting a series of general, the same webinar, but in a series with a general session. So you might want to join in for that on Tuesday next week, and one tailored for nonprofit organizations, again, on Thursday of next week. So please join us if you feel that those would be of interest to you. We will be recording this WebEx, so that you may refer back to the, the webinar, and if you want to share them with your colleagues. In addition, you may download, we have some helpful handouts here that we'll send to you at the end as well, but you can download them during the webinar. Please feel free to ask any questions, which we will answer time permitting. So without further ado, let's begin. So first question, because we have to address the title of the webinar. Michael and David, can you briefly discuss the idea of intent versus impact for the audience, and explain why we took this direction with our conversation?
Sure, I'll jump in, Carmela, and thank you for the introductions. My name is David Hall. For those of you who don't know me, I'm the Chief Marketing Officer at HBL. We're a boutique ERISA law firm, and we're headquartered in Atlanta, Georgia, and we serve clients in 39 states, and I'm just very excited to speak with you today. So the Secure Act 2.0, as Carmela mentioned, has 92 provisions, and so the reason we thought it would be important to think about the intent of Congress in passing this set of laws versus the actual impact to plan sponsors is because of the broad nature of the act. The act will impact different groups in different ways. So we started our series on Tuesday with a session covering more of a general overview of the act and talking about the intent of Congress and the impact to plan sponsors. Today, we're going to break it down a little bit more and talk more about provisions that we think small business owners should be thinking about. But the reason we're here is not to explain in greatly nuanced terms every provision in the act. The reason we're here is to get you thinking critically about how to use the act to your benefit as a plan sponsor. And so let's just jump into the question about the intent of Congress in passing Secure Act 2.0. So Secure Act 2.0 was passed into law December 29th, 2022. So this is a new law. And Congress stated in passing this act that they wanted to do four things. They want to expand employee access to retirement plans. They want to increase Americans' overall retirement savings. They want to preserve Americans' income. And then finally, they want to streamline some formerly complicated retirement plan rules for both participants and plan sponsors. And I think you'll see as we talk about several examples of provisions within the act that it's important as a plan sponsor to think about the intent versus the reality of the impact to your business before you run around putting provisions in place willy-nilly, right? So now that we've looked at the stated intent of the act, Michael, maybe you could speak to the areas of impact we'll look at today specifically, and then we can jump into some specific examples.
Absolutely, thanks, David. And for those of you who don't know who I am Michael McCabe from Trinity Advisors, and we are a retirement plan consulting firm, and we work with 401ks, 403bs, defined benefit retirement plans sponsored by a company. So, David, you mentioned the intent, the impact we don't know yet. It's very early in the race, and this race is actually going to be not a sprint, but in fact a marathon. There's provisions that take effect currently in year 2023, but there's also provisions that don't start until 2027. So right now, this is the $1 million question, is how is it going to impact you as a plan sponsor? And the reality is it's not a $1 million question. It could be actually a $5,000 question. We'll talk a little bit more about that as we move forward. But like all government regulations, it's not going to be easy or simple or clear for that matter. If you feel confused, you're not alone. Sometimes it even feels like to us drinking from a fire hose. So we are constantly learning more about this, and we'll share our experience and knowledge and expertise with you as we continue to move forward.
Thank you, Michael. And we did spend some time trying to break down some of these provisions in palatable bites. So would you kindly, Michael, kind of break down the areas that we'll be focusing on today that's going to have the biggest impact as it relates to small business owners?
Absolutely, Carmela. So we could spend a couple hours talking about this, but we decided to narrow it down to start to 4 topics. The first one is new tax credits that are available for startup plans. The second will be the treatment of long-term part-time employees and how that's going to impact your plan. The third piece is emergency savings. And lastly, we're going to talk about the safe harbor for employee elective deferral failures. So the Act has done a lot of things to help small business owners and decision makers as it relates to the plan.
Great. So let's start with the tax credits. We know there are a number of key points in Section 102 of the Act. Can you share with our audience some of those and the impact that it will have for plan sponsors?
Absolutely. So Secure Act 2.0 has new tax credit in it. Section 102, which is effective this year in 2023, provides startup credits of 100% for employers with less than 50 employees, up to a maximum 5,000 for the first 3 years that a plan is in existence. From employee 51 to 100, it starts to phase out. These tax credits do not apply to expenses that are paid for from plan assets or expenses paid through participants through their investment expenses in a form of revenue sharing. So this has to be paid for by the company. Plus, there's additional credits, percentages that the amount that the employer contributes on behalf of the employee, up to $1,000 per employee. And that's phased out over a 5-year period. David, any other thoughts you would like to add?
Sure. I do think it's important to remember, because we probably have a spectrum of plan sponsors on the call, some of whom may already have a retirement plan in place or likely do have a retirement plan in place. So just remember, please, that this 100% startup credit is for new plans only that started in this calendar year or later. Another wrinkle that we haven't mentioned is that the employer must have at least one non-highly compensated eligible participant. So beyond that, keeping in mind the intent of Congress was to encourage small employers to form new plans, my main observation here is there's just never been a better time for a small business to implement a retirement savings plan. Now, if you're in the other camp and you already have a plan in place and it's a newer plan that you've put in place within the last couple of years, you're still in great shape, as you will continue to qualify for the existing 50% credit toward administrative costs as laid out in Secure Act 1.0. So for those new plans getting up and running this year, my first observation is that it's critical to maintain an exact record of your administrative costs so you can work closely with your tax professional to ensure you receive the full credit you deserve based on the newly modified credit structure. So just a couple other details. Again, being an ERISA law firm, we want to point out a couple of nuances here, again, not to get too deep in the weeds, but the credit only applies to covered expenses. These are called qualified startup costs. that are paid by the employer. So any expenses paid by the plan, for example, investment fees and things of that nature, are not eligible. So, and these are expenses that are considered quote unquote ordinary and necessary, paid or incurred in connection with the establishment or administration of an eligible plan, or the retirement related education of employees. So employee education falls under the credit. So these costs would include things like plan administration, record keeping, and employee education, but it's not clear if other expenses like advisory services relative to the plan's investments are also covered. So what we would say as an ERISA law firm is, if it's a reasonable interpretation of ordinary and necessary, then it's plausible that the expense would be eligible. That being said, please memorialize your process, ideally with ERISA counsel. Have a memo to file that talks about the decision you made and why you made it, so that if there are ever questions in the future, you've got a bit of a CYA. So as far as impact goes, Michael, it does remain to be seen, right? It'll be interesting to see the metrics after this year, and if we see an increase in the rate at which small businesses are putting new plans into place.
Thank you, David. And Michael, you did a great job explaining sort of the startup, was up to 50%, and now it's 100%. But to me, there's different layerings and timing of these credits. And what would you recommend? Like, what should a business owner do? Like, I don't think they'll find it in TurboTax, the answer, but what should they do to kind of determine if they can even qualify for these credits?
Carmela, that's a great question. All we do each and every day is work with retirement plans. A lot of advisors in our industry aren't real experts in this space. They kind of dabble in it. So my recommendation would be really to seek out expertise and experience, someone who focuses in on this area that can help you, wade through all these challenges that we're facing moving forward.
Well, thank you. So we are moving into the next section of our presentation. So we talked about tax credits, but we're going to be talking about a required change, right? So a lot of provisions in the Secure Act 2.0 are optional, but there are some required changes. So, and this will impact your plan design for employers moving forward. So one that is going to require quite a lift for plan sponsors is worth mentioning in Section 125 of the Act, and it's really referencing the long-term part-time employee eligibility. So, we essentially, legislators want to make sure that these long-term part-time employees are covered and have what we call coverage and that are eligible to participate in the plan. And so, Michael, could you describe the section itself and how it relates back to the stated intent of the Act? And David, can you close with some commentary on challenges as it relates to plan sponsors?
Absolutely.
I'll be happy to, Carmel. So this may be one of the more challenging sections of the Act that is actually required and starting in 2025. But it actually is going to look back starting in years 2021 for eligibility purposes. So the intent of the Act is to get more Americans involved in retirement savings. So what you're going to have to do is track what's called dual eligibility, and I'll let David take a little bit deeper dive into it. But the intent is to make sure that more Americans are saving for their retirement. So what you're going to need to do is keep very good, solid records of participants and hours that they are working from years 2021 forward, even though the Act is only starting in 2025. David, what else can you add to that?
Sure. So when we talk about dual eligibility, as Michael mentioned, you've got basically subsets of workers, right? And so traditionally, or the way that we think about 401k plans, is that your full-time workers are going to be eligible for the plan. Some plan sponsors put in provisions that allow part-time workers to to participate, but that's really been more up to the plan sponsor in the past. As a part of Secure Act 1.0, that prior act required employers to allow long-term part-time workers to participate. It was a requirement, and it specifically stated that except in the case of plans that are a part of a collective bargaining, that employers maintaining a 401k plan have to have a dual eligibility requirement.
Mm-hmm.
And so that requirement would look like one of two things. It's either going to be looking at employees with 1 year of service and who've served 1,000 hours in a 1 year, or 3 consecutive years of service where the employees completed at least 500 hours of service in 3 consecutive years. So Section 125, the section of Secure Act 2.0 that we're referencing now, reduces that 3-year rule to 2 years. In other words, you no longer have to do a 3-year look back if you're measuring based on if an employee had 500 hours of service or not. So it also, to Michael's point, just as a sticking point, it does provide that the pre-2021 service is disregarded. So you're going to start tracking specifically based on the rules of the provision in the Act. So my observation from the perspective of working at an ERISA law firm, and full disclosure, I'm not an attorney, but I know a lot of them, and I see how non-compliance for small businesses can have a negative impact, not only worse for small business, but also faster for small business, because of small businesses sometimes just, by nature of being a small business, having limited resources, right? So of all the sections that I'm familiar with at conversational level, this may require the most plan sponsor work, but especially for small businesses, I think this is important, because if you're not compliant, you will face fines and penalties, right? And so, for companies without a part-time workforce, this isn't a big deal at all. But so many companies, and especially small businesses these days, do rely on part-time workers. And a lot of companies are going to be caught off guard. There are changes to the look-back period. There are changes to how you do the calculation, right? So this all points back to the importance of plan sponsors keeping detailed and exact records of employee service, including hire and separation dates, total hours worked for every part-time employee. And again, caught flat-footed, employers could be in a real bind come audit time, or should an employee file a complaint, recognizing that the employer isn't acting according to the new rules. So again, just a great example of where it pays for plan sponsors, and especially in our case this afternoon, talking to small businesses, pays for you to be proactive and to keep great records. So memorialize, keep track, memorialize, keep track, right? Can never do enough of those two things.
Well, now, David, Michael, David, you hit the nail on the head when you say small businesses, have challenges as far as the people that work on these retirement plans wear multiple hats. And now there's more kind of record keeping, if you will, that they have to do. So where would you recommend a small business owner to get the help or support they need to serve as a strong partner as it relates to this new provision and keeping making sure that their plan is compliant?
Carmela, another great question, which I'll start with. And David talked about dual eligibility and the importance of tracking this. We do this every day with our clients who have already dual eligibility in their plan. And it's interesting how many times we have to go through the process to make sure that we include everybody and that we're doing it correctly. It's an arduous task, but we believe it's one that needs to be really focused in on. And especially with the new act that's changing, it's going to be very important for plan sponsors to get help to make sure they're doing it correctly.
Thank you. And I would expect that, record keeper, TPA, serve as the team that kind of pulls it together and makes sure these, your plan's in compliant. So moving on to savings, right? You can't talk about retirement without talking about savings. So we're going to talk about emergency savings. And gentlemen, can you share with our audience some of the key parts of Section 127, what the goal is of this provision, And I think, David, you're going to jump in first on this.
Sure, happy to. So, you know, going back to intent, we always want to link intent to impact where we can. And you see with these emergency savings accounts, and Michael was kind enough the other day to give me some industry nomenclature. These could be called sidecar accounts in industry terminology, but we're looking, or Congress is looking to both increase American savings, but also preserve income and expand access. So let's think about how this particular provision might help you as a small business, help your employees do that. So this is Section 127 of Secure Act 2.0. It's going to be effective in 2024, okay, and it is optional. It provides employers the option to offer their eligible non-highly compensated employees only emergency savings accounts as part of the process of 401k plan enrollment. In other words, you're going to say to your employees, as a feature of our 401k, I am making this available to you unless you opt out. So an employee's contributions, which must be held in a limited number of principal protected investments, are treated as Roth after-tax deferrals, and then they're put into this sidecar account, separate from the individual's 401k account. And those are treated as Roth after-tax deferrals, and they stop after the account balance meets or exceeds $2,500. Okay. Then employees will have 100% tax basis in that after-tax contribution, and any investment earnings will be distributed tax-free. So while the employer may design the plan to auto-enroll eligible non-highly comped in the savings account, the employee, again, may always opt out. So this is one of the conversations we actually had early on about employee perception. So this really ties into the first three, again, stated intentions of the Act. So expanding employee access. Employees who might not have participated in your plan as a small employer due to a perceived inability for themselves to save for emergencies, for example, or a perceived perception, you know, that they can't do both, those people are more likely to enroll because now they have sort of an automatic outlet to have some emergency savings. The goal of increasing Americans' retirement savings. So at the separation of service, employees can actually take this account as cash, or they can roll it into a Roth DC or an IRA. And then in terms of preserving Americans' income, this type of provision, if you choose to enact it, could help to minimize the level at which individuals have to take on debt in order to address an emergency. Okay, so again, to me, as someone who is part of a small business, this looks very attractive, but you need to think about your employee population and if this is going to be useful to them or not. And there's lots of variables that go into that. Michael, did you have any additional thoughts on this?
Yeah, absolutely, David, and thank you for that. First off, we have to understand that this is totally optional, right? The employer has the option of implementing, and as David said, the employee also has the option to opt out. We see this every single day when we do employee education. We know that individuals can save on their own, but often far too many fail to do so. So there was just a report put out by the Federal Reserve that said almost half of Americans would struggle to cover at least a $400 emergency expense. So at that point, many are forced to tap into their retirement savings. And another recent study showed that in the past year, almost 60% of retirement account participants, potentially your employees, who lack emergency savings, tapped into their long-term retirement plan. So 60% of people are using their retirement plan as emergency savings vehicle, which is not a good thing. So what we think is that by separating emergency savings from someone's retirement plan savings, it will provide better understanding of one account is for long-term and the other one is for emergency short-term.
Thank you, Michael. So I know we're running up against the clock here. We have about 5 more minutes with you. And I think I'm just going to briefly mention the safe harbor for employee elective deferral and then kind of provide a summary. and conclude our webinar. So I think it's important to mention to the audience today that the Secure 2.0 Section 350 basically provides you as the plan sponsor with a safe harbor if there is a mistake made on elective deferral failures, right? So if you have auto enroll or auto increase in your plan and it's corrected within 9.5 months after the end of the year in which the error occurred, obviously favorably to the participant, they have to be made whole, and consistently among similar participants, that's a safe harbor. So meaning the plan sponsor won't incur any kind of penalties, etc. So again, there are a couple of these types of provisions in the Act, but I wanted to bring this up because, again, mistakes happen, especially when you're wearing, multiple hats and you're doing multiple things. But we're happy to talk with you about this in more detail if you feel that if this is a concern of yours. So finally, just kind of summarize here some key takeaways. I think you really need to focus on what's mandatory and what's optional, right? We covered like one mandatory thing today, but there are several that are coming down the pike. And obviously you want to look at your employee demographics and your business and say, hey, these optional provisions are great. They may work great for retention and attraction within your employee base, or they may not. So it's something that you really need to think strategically about. And then you want to obviously, concurrent with that, you want to look at the costs, right? There might be some costs incurred, but there might be a great benefit too. So you have to weigh those appropriately. And then finally, you want to I would recommend making, when you make changes to your plan, look at your overall plan design, right? There might be some other features in your plan that could be updated or might work better, with some of these new provisions. So it's a good opportunity to look at your whole plan, especially when those mandatory provisions kick in, right? Because you're going to have to make those changes. So that's my final comments. I know Michael and David, would you like to kind of add some final words?
Michael, go ahead.
Yeah, sure. We know this is going to be complicated. We know it's going to be a multi-step or multi-year process. And we are here to help. Happy to answer any questions that you may have. Use us as a resource. If it's not us, just make sure you speak with someone who has real expertise, knowledge, and experience. But again, thank you for joining us today, and I hope you found it helpful.
Great. And just to conclude, again, thank you for joining us. This is meant to get the conversation started. Again, this is not meant to be an exhaustive review of all the provisions, obviously, of Secure 2.0. And just, before we jump off to Carmela's point about the safe harbor for deferral failures, Section 350, I gotta just get this in because we are an ERISA law firm. I think this section of the Act is great, right? But these provisions are not an excuse to take a lackadaisical approach to your compliance paradigm, okay? Just because you get a little bit of a breather doesn't mean that after 9.5 months, you're not gonna get hammered. So please make sure you're talking about this with knowledgeable professionals like Carmela, like Michael. If you don't have ERISA counsel, I would urge you to engage ERISA counsel to help you think through these things and through strategic plan design opportunities that this Act affords. So with that, I will say thank you. Please take a look at the handouts. All of you will receive a follow-up email from the three of us tomorrow, which will include a link to both the general session, which was recorded Tuesday, as well as today. And we do hope that you'll stay for just a moment after the presentation to answer a very brief survey that will help us to do our jobs better in the future. So thank you again for joining us. And on behalf of Michael and Carmela, we appreciate you being here.
Thank you.
Have a great day.